Whenever you're ready, I'll tell you what we're thinking.
Okay, so do I need to go through the motion and then get an updated report?
Not if the court agrees with what we've proposed.
Okay, I guess before you even tell me what it is, I'm probably gonna want all the information on what he's been doing and the new offenses, but tell me what you're thinking.
We are thinking safety might be appropriate, Your Honor, since he was put on probation on the 2 felony cases up in Smith County. I had also extended a time offer of 3 years, which he considered, but I think his preference is if the court will let him do safety. We have a lot of counts here. Just so the court is aware, originally this MTRP was filed when he no-showed a judicial review on November 4th.
Okay.
And then shortly after that, around November 25th is the offense date for the Smith County cases. And so that's what the first amendment motion was for, and then the second that was adding a misdemeanor related to those charges.
So in Safe P, I'm looking at this. I guess, what is the allegations for why Safe P would be appropriate? Is there a drug issue?
There's certainly.
Yes, in September and October, there is on count 6, an allegation that he was intoxicated.
Mm-hmm.
And Judge, I'll tell you, the Smith County cases arose out of an altercation with a girlfriend and a friend where apparently they disposed of pills of his because of how he was acting, and he threatened her and pulled a knife on her and then assaulted the other friend. And that's what I believe he's pled guilty to and been sentenced to probation in the city of Tyler, Smith County. So obviously there's a drug issue. His history is, as a juvenile, for what we're hearing now and for what he did in Smith County, all involve assaults and some serious problems with violence, Your Honor.
And I do think Safe P would be appropriate as well, Your Honor, because in regards to the November 4th date, which he failed to appear for his administrative hearing, he was in the hospital due to some self-harm. And so that was the reason why he did not appear on that day, because he was in the hospital.
So whatever the court wants to do, we're fine with. We just wanted to let you know what we thought as a possible solution.
Why do you have a black eye? Got into a fight in jail?
Yes, ma'am.
Anna, you have his.
I reviewed that report, Your Honor. I guess you're going to read it anyway, but looks like somebody stole something from him in the dorm, and when he can probably look at it, right? And there's an incident or two in the last few weeks also, more than one of, I think, disrespect to the guard.
So, Dan, why don't you tell me why you think I should not put you in prison today?
I've never really followed through with any treatment programs before, and kind of have to go to prison now, so I really don't want to go to prison. So maybe if I can obtain some of the information, I might be able to turn my life around.
And so here's the thing, you've been coming here for a while. And I've read about and we've talked about and I understand somewhat and empathize with what you've been through and where you've come from and the issues that you've had to deal with. But at some point, you have to take personal responsibility for the rest of your life and the circumstances of your life before. You have to be able to say, you know what, that was awful, it wasn't great, it wasn't fair, but I'm going to do something different and I'm going to quit doing the same thing over and over again and kind of blaming that didn't have a great upbringing like some other people maybe. Does that make sense?
Yes, ma'am.
And it's gonna be no one's fault at this point but your own. You will be given, you already were given here, all kinds of opportunities. And I'm very hesitant to go along with this, because what you're doing is not just using drugs and not showing up. It's the violence that I have concerns with. And that at some point, I don't want it to be on me that I let you out, that you really, really hurt somebody or killed somebody or got yourself killed, because that's where this is headed. And understand that, was it Tyler County has
Smith
given?
County.
Smith County.
Smith County. So what about the Tyler
That's an
County?
error, Judge, I meant to correct. It should.
Oh.
It's Tyler, Texas,
It's the
but it's
confusion
Smith
between
County.
City of Tyler and Smith County.
So what, let's do this. I'm going to print this out. So what they did in Tyler, by giving you that opportunity, kind of puts me in a position where if you're on probation there and I give you some amount of time, you're still going to get out and be on I understand why Mr. Nichols and Ms. Holmes have come up with this agreement. But I want you to understand that if I send you to Safe P, two things, and you're not the first person I've said this to today. You're going to have some amount of time while you're waiting in our jail to go to Safe P. And then once you get to Safe P, you're still incarcerated. And any incident reports that happen, any incident in our jail or Safe P is going to be a violation of your probation before you ever get back out. And I won't care what they're doing in Tyler. I don't care if they keep you on probation, you'll be done here. And it's not going to be for a little 3-year sentence. Do you understand that? So this is the opportunity, those people at the jail that are working there and just trying to go do their job every day do not deserve for you to speak to them the way you do, to treat them the way, to not follow the rules. I know, I mean, I'm not going to say on the record, but I mean, I guess my concern, if you really don't want to be in jail, the way you're talking to some of these people, like, I don't give a, if you write me up and you can't tell me what to do kind of stuff, doesn't make me feel like you're really going to be able to do this. If you really want to, it's up to you. It's just a mindset change. You're going to be given the opportunities, but I want to know, and I will be checking, my staff can check every day until you get to Safe P. Anything else happens, they're going to file a motion to revoke, and we're going to be right back in here within a couple of weeks if necessary. Do you understand? This is your final chance. That's it. Don't come back in and no excuses after this point. If somebody else gives you another chance in another county, that's on them. You're not getting another one with me. I want to go through the motion though, because I want record of what he's either pleads true or not true to, so that I know kind of when I look back what we talked about and what we did and what was pled to before I agree to do anything. So, Mr. Wizard, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you put your hand down, and will he read the formal will he waive the formal reading of that motion?
Yes,
And so before we go, Mr. Nichols, did you want to make a
Judge,
amendment?
two things. I will drop count 1 for failing to appear at that hearing based on the conversation I had with Ms. Holmes.
Okay,
And then on count 9 and count 10, change the county, which currently reads as County of Tyler to County of Smith on both of those counts.
any objection?
And I
Okay,
believe it's correct on the other. Okay, yeah, I think that's all I need to change, Your Honor.
all right, thank you. So, Mr. Wizard, I'm gonna go through this motion. It shows in cause number 240198, you were placed on probation July 1st of 2024 for the offense of injury to a child, elderly, or disabled individual. And that was a 3-year deferred probation, is that correct?
Yes, ma'am.
And I guess also, I'm going to go through this, but I am inclined based on this to extend that probation for some amount of time based on the allegations as well. So we'll get to that in a minute. Count 2 alleges that you did not work faithfully at suitable employment and provide verification of that to probation. Is that true or not true?
It's true.
Okay. Count 3 alleges that you did not provide verification of performing community service hours as required. Is that true or not true?
I couldn't, probation wasn't transferred from one county to another.
Okay, I'll put not true there. Count 4 alleges that you were at a location other than your residence at 4:04 a.m. on September 24th, 2024. Is that true or not true?
Not really true.
Okay. Count 5 alleges that you did not enroll in services at the Spindletop Center as ordered. Is that true or not true?
Not true.
Count 6 alleges that you failed to never become intoxicated or under the influence of any intoxicated substance, and that you were on September 27th and October 19th of 2024. Is that true or not true?
It's true.
Count 7 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true? I'm not too worried about number 8.
We can abandon that count, Your Honor. Count 8.
Count 9 alleges that you were arrested for the offense of aggravated assault with a deadly weapon November 24th of 2024 in Smith County, Texas. Is that true or not true?
True.
Count 10 alleges that you were arrested for the offense of assault causing bodily injury November 24th of 2024. Is that true or not true? Count 11 alleges that you were at a location other than your residence at approximately 19 p.m. on November 24th of 2024. Is that true or not true?
Not true.
Count 12 alleges that you were arrested for the offense of assault on a family member and by impeding breath or circulation November 24th of 2024 in Smith County. Is that true or not true?
True.
All right, so did you enter your pleas of true to counts 2, 4, 6, 7, 9, 10, and 12 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes,
All right, then at this time, I'm going to find that you entered your pleas of true to those counts freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I am going to continue you on probation. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the Safe P program and any aftercare and things like that. The thing about this is you're going to get all kinds of tools at Safe P to help you make better decisions, to get a grip on whatever you need to. If there is a need because of, I know there was some mental health issues and treatment, it might be that special needs Safe P is the better. I'll let probation look at the history and see what's best for you so that you make sure you have the tools. When you get out, you'll have help to assimilate back into society and halfway houses and things like that. Again, this is your opportunity, because if you do not follow through with this, if you violate while you're in custody, if you violate again while you're out of custody, we will not be back here having the same discussion, and it will not be a discussion about 3 years or anything like that. You can be back in here, your probation revoked, found guilty, and I can send you anywhere in the range of punishment. I don't have to let them negotiate. It can be up to 10 years. Do you understand?
Yes, ma'am.
Okay, take advantage of this opportunity, all right? Okay, you can go back with the bailiff.
Thank you, Your Honor.
Thank you. All right, are you Dylan Wilkinson?
Yes, ma'am.
And Mr. Wilkinson is charged in cause number 250260 with deadly conduct, discharging a firearm. And Ms. Holmes has filed a motion asking that I reduce the bond, which is currently set at $100,000. There was a non-appearance, is that correct? A bond forfeiture for non-appearance.
And that's what we'll address here, because he bonded out in Smith County, so he actually did post a bond, but Jefferson County apparently didn't get word of it. So he was in custody in Smith County, posted bond, but still had the warrant here. And so when he came to Jefferson County, he was rearrested. And then it was set at 100,000.
But I show there was a bailiff's call. There was a court date set. Yeah, there was a court date set that, on May 19th of 2025. There was a court date and a bailiff's call, and He was not
here.
here.
I never knew of a court date. I never knew of Per the bondsman, after I had spoken to her, she said, basically, she told me on the ISTC phones up there at the jail when I got arrested this time, she said that Jefferson County was highly pissed I had gotten, I was able to make bail, and that for 4 months that they had not known that I was out on bail. And then she said I needed to take care of the stuff in Jefferson County and that she was no longer my bail bondsman. And that was the last time I spoke to her.
She doesn't get to say that, so,
But,
but that's why you probably didn't get
that's what she
notice
told
of
me.
it. This is from a Big Green Bail Bonds
That's the woman I had spoken to.
in Tyler.
Yeah,
Okay,
Because I wasn't sure
yeah,
why.
that's Smith County.
I wasn't
Tyler,
exactly
Texas.
sure why I was rearrested again, and she never really could give me a straight answer.
and she never told you about a court date.
No, no. And you're saying I had a court date on what date you said?
May 19th.
This one might have been the court date.
What were you arrested for in Smith County?
The charge from here.
Just that he turned himself in Smith County, thinking he posted the bond, but
Okay,
I don't know.
and the initial bond that they set, I guess, did
It was
they set it or did I?
10,000.
They said it, they're.
That was 10,000. Let me read this real quick. They also did file an AFRS to get off the bond. But the bond forfeiture overrode that, so that might be why she. For everyone's information, I'm reviewing the probable cause affidavit, which obviously makes me have some concern on what the allegations are that you did. So where do you live?
I'm going to be staying with my mother.
With your mom?
Yes, ma'am.
Where's that?
One street over for Brinkman Drive in PA.
In Port Arthur?
Yes, ma'am.
What is the address?
3965 13th Street.
396532.
And what is your mom's name?
Monica Osman.
What's the last name?
Osman, Ozmun.
Is there any criminal history that you know of?
There's a misdemeanor DWI conviction and a very extensive juvenile history from Henderson County.
Okay.
Several adjudications for unauthorized use of motor vehicle and burglary vehicle.
And I'm-
So,
And I believe those were over 10 years ago.
It can't be that long ago because he's only,
He's 25.
okay.
I think they're
Yeah,
around 2015.
okay.
And the complainant, is my understanding, she doesn't live here, she lives, in the reports that state she lives around like the Dallas area, like Kemp, Texas, where is that? I think that's up near the Dallas area.
Okay,
There's two complainants.
yeah,
Oh,
there's one here and one there.
Yes, Your Honor.
but the girlfriend lives up near the Dallas area.
Haley Murph.
Yes, ma'am.
When's the last time you had contact with her?
It's been at least 9 months to a year. I haven't spoken to her since well over last year. I don't know whereabouts, I don't know where she's at. Last time I've heard anything, someone had told me that she was engaged and moving to Colorado.
Second. And do you know this Samantha Grant?
No ma'am, I've never met her before.
Mr. Nichols, what's your position?
Whatever the court decides as far as bond, I just ask it to be sufficient to make sure he appears. I'll let the court know there's some cooperation issues with the girlfriend of the victim, but I have seen nothing to concern the other victims, so I intend to push this case forward, Your Honor.
Okay. All right, so here's what I'm gonna do. Mr. Wilkinson, I'm going to grant the motion to reduce your bond. I'm going to reduce your bond to $30,000. If you make that bond, there are several important conditions of it. The first is that you have absolutely no contact, no communication in any way. That's obviously in person, but it also means through social media, sending messages through other people, anything like that, with either Haley Murph or Samantha Grant.
Yes, ma'am.
Also, you are going to be ordered as a condition of that bond to live with your mom, Monica Usman, at 3965 13th Street, and that is the only place you can live. You cannot move unless you ask my permission. You're also going to be required to wear a GPS monitoring device at all times and remain in Jefferson County unless you have my permission. Do you understand that as well?
Yes, ma'am.
All right, any other conditions or?
I think that'll do it, Your Honor. Thank you.
Yes, ma'am, if you can.
Okay, so, he does have a job that requires travel, Your Honor. How would that work as far as, do we need to
I need
contact
this.
the court?
Yep. I want specific information about, you need to get that to Ms. Holmes. And so if you make that bond, a couple things will happen. One, if you make the bond, you need to know now that you will be required to at least try to hire your own lawyer. So that's something you'll need to keep in mind. Ms. Holmes will stay your lawyer unless that happens. But as soon as you get out, if you have a job that requires travel, you need to let her know, employer, get something in writing, where you go, things like that. She'll get it to me through a memo with Mr. Nichols involved in it, and then I'll say yes or no to that. You cannot leave unless you have my permission, so you've got to stay in touch with her. She gets to me, and then you'll see if you, and I mean, we want you working. I just need to know where and what the company is and all that kind of stuff. Okay?
Yes, ma'am.
All right, you can go back with the bailiff.
Okay, maybe,
You see what I'm saying? At
yeah,
the
it
top,
wasn't one of the allegations, that's probably looking the wrong thing.
because the motion was filed way back then, I guess.
Right.
So that's why it hadn't been. Good morning. Are you Jeremiah Johnson?
Yes, ma'am.
And Mr. Johnson was previously here in cause number 250330, entered a plea of guilty to aggravated robbery, and 250331 also pled guilty to aggravated robbery. Cause number 250408 and 0409 pled guilty to theft of a firearm. The agreement on these were for a 10-year deferred on those two aggravated robberies and a 2-year term probated for 5 years on the theft of firearm cases. I've received the pre-sentence report. Has everyone had an opportunity to review these reports?
I haven't.
Or the report? Are there any additions or corrections?
None of them were, Judge. Optimistic.
So I don't know about all this. Not real sure I want to go along with this plea agreement. Mr. Johnson,
Yes, ma'am. I promise that I'll do right this time.
this time,
Yes, ma'am.
you have been in trouble for breaking into people's cars, stealing guns, shooting at people over and over and over again.
Yes, ma'am. God can show me that this is not nothing I want to do in life.
When did he show you that?
Being in jail, incarcerated.
You've been in jail before. You didn't find God when you were there before?
Yes, ma'am. I'm not making no excuses.
Here's the thing. I hope you have.
Yes, ma'am.
I hope that you have found him. The problem is you lose them when you get out of jail.
Yes, ma'am.
And that's what a lot of people do, is when you're looking at time and you're incarcerated, you're like, oh, I don't want to do this. And then you get out and you go start doing the same thing because you think you're cool and you're going to go steal guns and you're going to shoot at people when they,
Be there for my
you're
little
lucky
girl.
you're not here for murder.
Yes, ma'am. I gotta be here for my little girl. I can't mess up no more. I can't afford to.
You're how old?
28.
You're 28.
Yes, ma'am.
You're way older than old enough to know better. You know, this is something I see a lot of times with these 15, 16, 17, 18-year-old kids. Your child's 7 years old,
Yes, ma'am.
so it's not like you have a baby and all of a sudden you know you need to be there for her.
Yes, ma'am, I know. I made a few mistakes in my life, but I'm willing to try to.
That's an understatement, don't you think?
Yes, ma'am, I understand.
I appreciate too that you're being honest with me today.
Yes, ma'am.
But I have to look out for the community as
Yes,
much as,
ma'am.
you know, I kind of have two things I've got to do here, figure out what's best for you, but also what's best for our community.
Yes, ma'am.
Your Honor, I will say when I first met with him that, I mean, early on, he's just said, I'm tired of this life, you know, I don't know why I'm doing this and I need to get my stuff together. And
Yes.
do you have people, I understand exactly what the court says. Everybody finds God and, I mean, Jesus in jail, you know, but sometimes I think there's some truth that when you're sitting there and it opens your eyes that, you know, you do realize that I'm getting too old for this. I'm just ready to settle down and do what's right. And he seemed to have that attitude when I first talked to him.
Yes, sir. I mean, I just ask if you give me one chance, just one chance to prove myself.
So I want to make sure, and we're going to go over that. If you get this chance and you violate it,
Yes, ma'am.
you got the rest of your life that I can give you in prison.
Yes, ma'am.
And when I have to spend some time and it bothers me, a lot of times I don't remember. People say, oh yeah, you remember when you put me on probation? I don't. I'll probably remember you,
Yes, ma'am.
especially because you put things on your face so people can remember you by them. Probably not the smartest thing either, right?
No, ma'am.
Okay. Any reason not to go forward with sentencing, Mr. Smith? All right, so here's what I'm going to do, Mr. Johnson, because of my concerns.
Yes, ma'am.
I'm going to give you an opportunity, but I'm going to hopefully give you some tools to be successful.
Yes, ma'am.
I'm going to find in each of your cases that you enter your pleas of guilty freely and voluntarily,
Yes, ma'am.
and find sufficient evidence to find you guilty. In cause number 250330, defer all proceedings, place you on probation for a period of 10 years.
Yes, ma'am.
You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'm going to go through certain conditions in a few minutes. In cause number 250331, find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You will pay a $500 fine in that case as well and follow all of the rules and conditions of probation. In cause number 250408, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that, you'll be on probation for 5 years in that case. You're also ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Cause number 250409, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. And you're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. One of the conditions of your probation in each of your cases is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program, so you're not getting out today. But I'm doing this to continue you hopefully making the better decisions. This program is all about making better decisions. Staying away from the people that you need to stay away from. If you really want to change your life, you can. People do it. It's not easy sometimes, but you're going to be given the tools. And if you don't, then you're back here, okay? And so here's something that's very important though. You have a handful of write-ups in our jail.
Yes, ma'am.
I see those. I'm going to see if you have any more between now and when you go to ISF. It will be a violation of your probation if you have more incident reports in our jail or if you have any in ISF.
Okay.
So if you are disrespectful to those officers that are just out there doing their job, if you're fighting, if you don't button your jumper up because you're too cool to button your jumper up, just follow the rules. When you're out and you're not in custody, you can make whatever decisions you want. When you are in custody, you're gonna follow those rules. If you don't, again, that's part of your probation now, is that you follow all of those rules and don't get in trouble. You could be back in here on a motion to revoke your probation before you ever hit the streets again.
Yes, ma'am.
So whatever's going on in the jail, you better go in and say, whoever else is messing around, get on your bunk, do what you're supposed to, get to ISF, get out, do what you say you're gonna do, okay?
You said how long, ISF?
It's a 90-day program, okay? So you've got two separate things going here. Now, you've got the deferred probation on those aggravated robberies, which means at this time you don't have a conviction on those cases. That's a great thing for you. It also leaves it open, though. If you violate any condition of your probation, you're back in here. I can convict you of those offenses, and you could be sentenced to anywhere in the range of punishment, which is between 5 years and up to the rest of your life in prison, the whole range of punishment. Also, if you violate on those theft of a firearm cases, you've already agreed in those to the maximum punishment, which is 2 years in the state jail prison. So if you violate, you've already agreed to those 2 years. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Not just any charges, more felony charges. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you can, or how long that lasts, you can talk to Mr. Parker, all right? Good luck. Take advantage of this opportunity. Good morning. Are you Gerson Mendoza?
No.
And this is cause number 250304. Will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Mendoza, you're charged with the first-degree felony offense of aggravated robbery from December 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with?
No.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis, with the interpreter? And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, that you're waiving any right to appeal? And it looks like the agreement that you reached is for a 10-year deferred probation, a $1,000 fine, and you would be required to follow all of the rules of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yeah, entiendes? Yes, ma'am.
And state tenders number 1,
No objection, Judge.
it's admitted. Is there any evidence that Mr. Mendoza is not competent?
No, Judge.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing so we can get a pre-sentence report done that'll give me more information about you and your case, and then we'll come back later for sentencing. What is the state's position with regard to, a bond? Based on the nature of the,
History is young age, he's 18 years old, which was several classmates that was less,
I can't hear you.
I think he was less than the other defendant. There's a co-defendant in this case.
I'm not gonna change the bond based on his age and the nature of the offense. A lot of times what I do in these is possibly ISF or something anyway, just because it had to do with a robbery and a weapon, and he's young, so, let's just see what the pre-sentence report says. All right, so you can go back with the bailiff. Thank you, Ms. Parrish. Good morning. Are you Deontay Wayne? Or Deontay Wayne Reed, I'm sorry. And Mr. Reed was previously in court and cause number 240838, entered a plea of guilty to the state jail felony offense of theft of a firearm. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah, Judge.
State has, Judge, I suspect it's something on page 1 of the court. I have.
Mr. Lewis?
Yes, ma'am, Judge. I've spoken with my client about this, as far as his assessment accountability and for his admission to this offense. At that time, I could tell you, Judge, after speaking with him, he understands the issue with that, as far as his making a decision to try to get probation, as he's talked about here in the PSI. That this would involve him not just taking responsibility, but being honest and truthful about his plea, whether he was guilty or not guilty. And of course, at that time, explaining to him that way, he's prepared, of course, to truthfully admit to his involvement in what he did in his offense, which he says he did commit this offense at the time.
So you either did it or you didn't do it. And so if you did it, then you're getting a great opportunity. If you didn't do it, then that's what juries are for, and that's why you would go to trial. So did you do it or did you not do it?
I did it.
Okay, and do you want me to go forward with this? So what happens is you're gonna be spending some time with probation. And you've got to be honest with them the whole time you're on probation. They're there to help you. And so if you try not to take responsibility and try to diminish things that you're having issues with, then you're going to end up right back in here and looking at going to prison. So it's very important that you're open and honest with them. Do you understand?
Yes, ma'am.
Okay. All right, then, any reason not to go forward with sentencing? All right, Mr. Reed, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that. You'll be on probation for $1,000. You will also be ordered to pay
Is that probation for 5 years?
5 years.
What did I say?
$4,000.
It's been a long morning. Y'all are all like, what is happening to her? Okay. You're going to be on probation for 5 years. You're going to be ordered to pay a $1,000 fine. I was reading faster than my mind was going. You're ordered to pay $1,500 in restitution also, and to follow all of the rules and conditions of probation. If you do that, this is a good opportunity for you because you're going to be able to serve that 2-year sentence while you're out on probation instead of in state jail prison. The other side of that, though, is if you violate any condition of probation, you'll be right back in here and you'll be looking at that 2-year sentence that you've already agreed to. Do you understand? There's going to be, I want you to get your GED is going to be ordered for you to get your GED. That's to help you so you can get better jobs and do better things. There will be mental health treatment if you need any kind of issue. Everything that they offer you and tell you you need to do is ordered, and so you're required to do that, and it's all meant to help you, okay? So you're welcome. And so I'm handing you somewhere the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Yeah, I think I'm out of my words. Good morning, sir. Are you Desmond Jones? And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Jones, in cause number 250610, you're charged with the state jail felony offense of unauthorized use of a vehicle. That's from March 28th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle, sentence you in accordance with that agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. Good morning. Are you Tilia Mills?
Yes, ma'am.
And will your client waive the formal reading of the
She
indictment?
will, Your Honor.
Ms. Mills, in cause number 240549, you're charged with the state jail felony offense of theft with previous convictions from November 4th of 2023. The indictment alleges you were previously convicted of theft July 14th of 2022 on 2 different cases on that date in Montgomery County, Texas. And then after those were final, you were convicted 2 times on June 21st of 2023 of theft in Harris County, Texas. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mills is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. You can go back with the bailiff.
Okay, this one.
Renesia Segura, Ms. Holmes?
Yes.
I feel like they've just lots of work. Oh, this is an MTRP. Good morning. Are you Renesia Segura?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Segura, in clause number 231869, I have a motion to revoke your community supervision. Shows that you were placed on probation July 29th of 2024 for the offense of theft of property with previous convictions. And that was a 2-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of theft in aggregate amount January 29th, 2025 in Harris County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, and that you were at a location, you were arrested at a place where a crime had been committed with individuals who had previously been convicted of crimes. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
Give me a minute here.
Judge, I'd reviewed some of the Harris County offense material. She was essentially an accomplice while other people were committing theft in this instance.
I'm gonna real quick look back at the pre-sentence report to see that the criminal, how many we've got.
A lot, and I won't say it.
Oh, yeah, no, I'm not accepting this. My notes, I sent you to ISF already. And my note says it was a cap of 15 months at that time. And I wrote on here that you deserved the whole 15 months. And it's like Mr. Lewis was your attorney at that time. And he and Ms. Holmes are both doing quite the job for you. But 8 months with 7 felony convictions for theft, 5 more arrests, plus this one, and now you've been arrested again, is not something I'm going to accept. Absolutely nothing less than the 15 months that was the cap in the first place. So it's either something like that, or it's an MTRP. I don't have to, y'all go talk about it. I'm deleting the paperwork. All right, go back with the bailiff. If y'all come up with something today, then that's fine. If not, we'll, but I deleted it. You'll need to redo something.
So the offer, we're unagreed on the type of probation. So
Okay.
State's offering straight, we're asking for deferred.
So it is an agreement with regard to probation, just not the type. Okay,
Yes,
thank you. All right, so are you Jalen White? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Let me get to it. Mr. White, in cause number 240038, you're charged with the 3rd-degree felony offense of possession of a prohibited weapon from July 7th of 2023. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it's my understanding that you have reached an agreement that I would give you a probation, but it is not agreed to the type of probation. Is that your understanding?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. White is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Ms. Holmes. She'll present it to me on your behalf when we come back. Did you have something?
Yes, Your Honor, I anticipate there will be at least one witness, a short witness at the sentencing.
Okay.
And a video as well, a short video. I don't know, if we just need a little bit more time than ordinary.
Let's just, we'll do it at 11.
Okay.
That way, y'all have plenty of time.
Yeah.
And, Your Honor, since this is a probation offer, although we're agreed on the type, would the court consider reduction of bond?
State's opposed to that, Judge. The alleged weapon that was possessed by this defendant was outfitted with a Glock switch. Actually, I don't want to misspeak. I know it was outfitted with a Glock switch. I think there was also 2 weapons that were involved in this entire occurrence.
Well, let's see. How old are you, Mr. White?
23.
There were 2 weapons involved, one of which was outfitted with a Glock switch, Judge.
Typically, on a probation offer like this, I would be inclined to do that. However, with the type of offense and the age of Mr. White, there's the possibility, like I have been on a lot of these young ones, that I will consider something like ISF, depending on what that pre-sentence report shows. And based on that, at this time, I'm not going to reduce that bond. Okay, you can go back with the bailiff.